Good afternoon. The Greater Downey Association of Realtors is proud to present everything you need to know about AB 1482. Now, before we begin, I want to let everyone know that they are in listening mode. If you take a look towards the right-hand part of your screen, you'll see a section that says questions. If you click on it, it will give you a section where it allows you to type and submit anything you want answered by us. Now, without further ado, I'm going to go ahead and introduce you to Josue Barrios.
All right. So thank you everyone for joining in, and thank you to the Greater Downey Association for putting this event together and for inviting me to kind of talk a little bit about AB 1482. First and foremost, I am a realtor like most of you. So I'm in the trenches with Keller Williams Pacific Estates, La Mirada. I also run a property management company, so I kind of see hands-on what's happening as a result of this bill. And also, as far as the Greater Downey Association is concerned, I also serve as a state director to the California Association of Realtors, as well as I'm finishing up my term as the region chair, which oversees about 5,000 members in this area. So I'm excited to talk a little bit about AB 1482, what it means, and most importantly, how it affects our business as well as our clients. We're going to go into a lot of questions, I'm sure, but I'm going to first kind of give a quick little brief on what this means and basically some of the highlights of it. There's a lot of it. Obviously, it's a bill, so there's a lot of the stuff. It gets pretty deep in the weeds, but essentially, I really want to kind of highlight how it applies to us, primarily as real estate professionals, and obviously how the value that we provide to our clients. So the first thing that we're going to talk about is, well, there's two main parts to this bill. The first part is what's called the rent caps, and the second part is just cause. So in the past, if you had a tenant in one of your listings, you basically could give them a 30 or 60-day notice. That's probably not going to be the case anymore, and obviously that's where it's going to affect our business. And I'll obviously I'll go into that into a little bit more detail. The first part is the rent cap. So the way it stands in the past, most municipalities, most cities, you can give anywhere of an increase as long as you gave proper notice. The way it kind of works now is it's 5%. It'll be 5% plus inflation, and it's going to be capped at 10%. So depending on what that is, it'll be somewhere in between 5 and 10. Right now, starting January 1st, the inflation is going to be 3.3. And so it's a little complicated the way they measure this, but we're going to give you guys handouts on how they kind of go about it. But basically, you're looking at the 5% plus the 3.3 inflation, so basically 8.3 is going to be what you're going to be able to raise the rent. Where it gets a little complicated is the timing, because this bill, it was signed October 8th. It's meant to take effect on January 1st, 2020, but we actually have to scale it back, or it goes retroactive to March 15th, which is when this bill was introduced. So basically, when you are looking at rent increases, you actually have to look at what it was on March 15th, and then basically apply the 5% plus the 3 going from there. If you are currently charging more than that, you are able to do that until January 1st, but then at that point, you do have to scale it back to what it was, like I said, as of March 15th, plus the 5 plus the 3.3. So hopefully that makes a little bit of sense. But that's where it kind of gets a little tricky. If a property owner is charging in excess of the 8.3, they're able to do that until January 1st. There's no need to actually repay anything that's gone above and beyond that. But as of January 1st, they do need to be in compliance. They do need to go back to the proper rent increase. All right. So from that point, we're going to go into just cause. And well, I'm gonna give, so keep in mind, these are my opinions. I also want to give a disclaimer. I'm not an attorney. I'm not a CPA. If there is, legal issues, do consult with your favorite, unlawful detainer attorney. I know that the Greater Downey has several affiliates that participate in that. So, but I think for most of my property owners, it's not so much the rent increases, because 8% is actually, it's not horrible. We can live with that. it's the just cause eviction. And I think this is where it plays more of a part into our industry and kind of the things that we're able to do. So so just cause evictions, basically what that means is there's what's called at fault and no fault. And these are basically going to be the only two reasons that an eviction will be able to be served. At fault is when they're at fault. The most common is non-payment of rent. So if someone does not pay their rent, then basically at that point you can start an eviction on them. This does not require relocation. So the other part of at fault could potentially be breaking a covenant, breaking the lease, breaking some form of the contract. It could be a nuisance. It could be a failure to allow entry. Obviously, it could be illegal subletting or pets, smoking, some kind of cause that basically breaks the lease. So that's what's called at fault. And again, those do not require the payment of relocation, criminal activity, basically any kind of material term of the contract. Unauthorized occupants as well as part of that. The other part is what's called no fault, and this is when the tenant is not at fault. So most of these do trigger a relocation fee. And so I know that in our backyard, we have the city of LA, which has, the rent stabilization ordinance, and they have their own rent control fees, which hover around like 20,000. If it's a no fault eviction, it'll the relocation fee is 1 month's payment. All right, and that could actually be applied in one of several different ways. It actually could be delivered as far as a check. It could actually be applied towards their last month's rent as well. So that's kind of some leeway in there. But what's a no fault eviction? It's when basically, they've not breached the lease, and it will require the relocation assistance. There's a few allowances for this. One is if the owner decides to occupy the property, their owner or their immediate family member. And based on what I've been given, that means either the owner themselves, their spouse, their domestic partner, their children, their grandchildren, their parents, or their grandparents. And so that would still trigger the relocation assistance, but that allows that property to be basically taken back in a sense. Another opportunity for that would be withdrawal from the rental market. So if an owner says, I'm not going to rent it anymore, then that's what's called the Ellis Act. They're able to withdraw. They're able to take it off the market, but basically at that point they do have to pay relocation. Substantial remodeling also qualifies for it, and based on what I've seen, that basically means anything significant. Structural, electrical, plumbing, or any kind of mechanical system that requires a permit. So if it's just cosmetic work or anything along those lines, that's probably not going to fly. But based on the language of the bill, it seems like anything that requires a permit from the city, or if it's unincorporated, or the unincorporated has their own areas, it basically requires a permit. And so that also requires relocation if you wanted to go about it that way. And basically, if there's a compliance with a government order, then that's that stuff that comes out from higher ups, and a lot of that's kind of beyond our control. But that's another option for relocation. And so part of this is all these come into play when the tenant has occupied the property for more than 12 months. And so if it's less than 12 months, then it could just simply be, what we do is it's a notice of non-renewal. That basically says you don't need to, the property owner chooses not to renew the contract, and then at that point, it's none of that is actually required. It still can go about a normal, like a 30-day notice of non-renewal. So what I've seen some property owners do is they're actually, they're doing away with the 12-month lease agreement. They're doing 6 months, even starting out with month to month, or I've even seen a few do like 10-month or 11-month, so that they're not kind of locked into that 12-month agreement. But as long as you give the notice before, then it's typically okay. At first, when I saw the bill, obviously I thought I was like, this is sky's falling. This is a huge game changer. But surprisingly, it's not. I mean, I'm not a big fan of rent control. Obviously, I think a lot of this, again, personal opinion, I think a lot of this will actually backfire. But there are exemptions, and basically, I think it's wise to know where this stuff doesn't necessarily apply. Number one is single-family homes, condos, townhouses, and that's under most circumstances. The exception to that exception would be if the owner is a real estate investment trust, if it's a corporation, if it's an LLC who has a member that is a corporation. But the majority of properties, if they're owned by a family or even by a living trust, and the title is in that, then they're exempt. So those properties do not fall under rent control or any of the stuff that we've talked about. Other exceptions include new construction, and that's basically anything 15 years or less, 15 years or newer. And so again, going back to City of LA is right now it's like October 1978. I just usually go with 1979. So that's going to change, which was in the news yesterday. So now City of LA has their own rent control ordinance, and they're going to keep their version of it. What they are adopting is the 15-year. So any properties 15 years or newer are exempt from rent control. And so in City of LA, now if you have a property that was 20 years old, before it was not subject to rent control, it will now be subject to rent control. All right, so, actually just on a certain note, just to talk about City of LA a little bit further, yesterday the City Council passed an ordinance prohibiting any more 60-day notices going out, because obviously some owners were freaking out. They wanted to get their properties vacated, the ones that fell into the gap of non-rent control in City of LA. And so obviously they just saw that there was a lot of evictions taking place. So they put a halt to City of LA to any kind of evictions happening in that in that little gap. So if you have a property in the City of LA, then you kind of, I guess you could say you missed the boat. But again, there's still other ways to, I think the biggest part is obviously understanding the law and how you can use it to benefit your clients. The other exemption is owner-occupied duplexes. And that falls into basically if you're a property owner who lives in one of these units, and basically you're renting out the other one is also exempt from rent control. That does not fall into rent control. If they're both being rented, then that is rent control. If they're both being rented and you move into one, that's still rent control. So you can't skirt the law that way. At the time of the bill, basically you have to have been living in one of those units in order for it to be exempt. And then that's the same for ADUs as well. And well, with ADUs, I think a lot of those are newer construction, so they still fall into the 15-year window. But if it's an ADU and if one of them is owner occupied, then again, it is exempt from rent control. Hopefully the stuff's all making sense. We will have handouts at the end, and so I did put together a little synopsis of everything that goes over all the details, all the ins and outs of the bill and whatnot. So, and then obviously we're here as a resource as well. So if you own property, what do you need to do? CAR is actually coming out with a form. It's called the Rent Cap and Just Cause Addendum. It'll probably be released around, I'm guessing November or December. It's still being kind of analyzed by the attorneys, make sure it's good to go. But this does need to be included to all tenants it does need to be included to all tenants if they fall under the exemptions prior to January 1st. Starting July of next year, it will need to be incorporated into the lease, but I'm pretty sure CAR is on that and they'll be included into that. So as far as this form, basically, if there's a current lease, then you could just do it as a standalone with what's the form with zip forms CTT, which is basically a change to the terms of tenancy. And you can kind of basically attach these two forms together, but they do need to be delivered to tenants prior to January 1st. I'm sure CAR is going to be on top of that and give us a lot more information as we kind of go forward. So as far as dates, I think there's a couple dates that we've talked about and we've highlighted them. There's three that really kind of stand out. One is March 15th, which again is the date that which is the basis for the rent increases. So anything kind of going after that is obviously you need to look at that date when you're figuring out when you're what you're eligible for as far as a rent increase. January 1st is the day that this bill takes effect, as far as just cause eviction and the rest of it being unfolded. And then July, I believe it's July 1st, where this stuff will need to be incorporated into the lease, into the actual lease itself, not as an addendum. Right now, starting January 1st, it'll have to be an addendum. I want to talk briefly about where they get the cost of living or the inflation. So it depends. Most of us, I think, are in Southern California. We are going based on what's called the Regional Consumer Price Index. And so there's a link also on the papers that I gave. So that's where it goes from April to April, and that's where we got the 3.3 from. If you're in a different area, thank you for joining us. You may or may not have your own. If your region does not have a CPI index or CPI, then you would be based on the California Consumer Price Index. But hopefully that kind of answers that. So I think at this point, we can basically start to go into questions if there's anything along those lines. I could try to hammer out as many things as I can, because I think a lot of the questions are pretty similar. But yeah, we'll start to go into that. So there are, I guess while we're waiting for that, there are a few other exemptions that could potentially qualify. This stuff, again, I didn't necessarily want to touch on it because it's not stuff that we're doing on a day-to-day basis, but like houses restricted by deeds are exempt, or housing restricted by deeds. Dormitories, if they're on campus, even actually, it's where it gets into section 8, it's a little vague, but basically the language I've been reading from CAR says that Section 8 properties are exempt from rent control. But we definitely need to clarify that a little bit more as we go forward. And then obviously if there's any kind of deed restricted properties or affordable housing, income restricted, I manage a handful of properties that fall under a HUD kind of home program. So they're 50% of average median income. So those, if you happen to have some of that stuff, then those are also exempt because the rents are typically, well, they're usually a lot lower. There is also going to be language that you have to include into the notices, and it's a paragraph, but again, that's all included in the handout that we have, which should keep you all compliant.
So Erica Stein says, what about ADUs?
ADUs, so far, the way that they're being treated, it's being treated in this case similar to duplexes, where if you are occupying one of them, then the ADU, as long as you're occupying the main house, then the ADU would be exempt from rent control. If the ADU is less than 15 years old, then that alone would exempt it.
And I got another question. Can you repeat the dates?
Sure. The relevant dates are, the first one is March 15th. And that the reason that day is important is that's the day that they're basically basing the rent increases on. So I'm going to give an example of this. Let's say, because honestly, a lot of people don't know that this happened, this bill's passed. So they're giving their normal rent increases. And let's say you gave a 15% increase to take place in August. You're able to take advantage of that increased rent with no repayment. But come January 1st, you have to figure out, well, you have to look at what the rent was on March 15th and base your rent increase on that date. So basically, it's retroactive, and that's the date that they're kind of going based on. January 1st is another important date, and that is basically that's the date that the bill is supposed to take effect. So that date is important because that's when a lot of the just cause evictions essentially start to kind of roll out. So everything else up until this date, obviously we kind of saw a frenzy of 60-day notices going out. And so that's when all that kind of comes to an end, that's when the bill actually takes place. And then the other date is July, and I want to say it's July 1st. That's when all the language is supposed to be included into the lease. But prior to that, I guess also part of January 1st is when we're supposed to deliver the notices that has that specific language that indicates either the exemption or the fact that it falls into a rent control property.
I have another question. Jose, each year the rent can be increased. If I increase the rent today, must I wait till October 24th, 2020 to increase the rent?
Good question. So it's on a 12-month basis. So if you can rent it, as long as you have not done an increase in the past 12 months, you can do one today, which would, well, I guess you would give your proper notice. And so if it's obviously so the notice times still apply. If you wanted to do, less than 10%, it's still a 30-day notice, and then start taking advantage of that new rate. But then come 12 months from that, you're able to do, well, actually, so you can actually do 2 rent increases. They cannot be more than the 5+ inflation. So if you wanted to do 5 months along the way and then do the other 3 somewhere along the way, then you could do that, but it can't be any more than the 5+ inflation. And that's over a 12-month basis.
Okay. Just cause eviction only applies to tenants who have occupied for how long?
12 months or more. 12 months or more. So again, what I've seen a couple property owners do is they give a notice of non-renewal, or another strategy has been just to kind of lessen the lease time. We're seeing a lot of month-to-month leases right now. Because it still gives the owner the flexibility, and obviously the tenant gives them the protection of knowing what the rents are going to be.
All right, I got a question from Francisco. If I'm renting a duplex property and I decide to remove one tenant and I move in, I still fall into rent control after I move in?
Correct. So you need to have been occupying the property as of when when the bill got enacted, in order for that to have to take effect.
What form do I need to provide my tenants for rent cap?
As far as the rent increases, it's your normal CAR. Obviously has different forms as far as the rent increases. The change in terms of tenancy. Rent increase forms is obviously make sure that they're still compliant. So if it's under 10%, so 30 days. But the CAR ones, they work. But also, like I said, they come December, they will release a new form that has the specific language that to deliver to the tenants, that has everything else that you need to do.
Does rent cap apply to commercial property?
Good question. I actually am surprised I haven't heard that one yet. No, it does not apply to commercial property. It's only residential properties.
What is rent rollback?
Rent rollback. So we talked a lot about the March 15th date. So again, hypothetical situation, you gave a 20% increase in August. And so that took effect in August 1st. So you're getting the extra 20% or the rent 20% increase for August, September, October, et cetera, et cetera. Come January 1st, you have to roll it back. It has to go back to, it basically has to be compliant to March 15th date plus the 5% plus the 3.3%. So it rolls back, not like Walmart, but like for compliance reasons, it needs to go back to March 15th plus 8.3.
Does the rent cap apply to properties in a trust or individual's name if the owner does not live in the property?
If it's a single family home, then it would be exempt. I kind of listed some of the exemptions. There are exemptions for single family homes, for anything newer than 15 years or newer, but anything above in that is still, it would fall under rent control. But as a trust, as an owner of a trust, you would be exempt if it's a single family home.
How should the notice be provided?
Good question. I see a lot of court cases that get thrown out because of proper notification. Again, the CR forms kind of walk you through this, but there's, you can either do personal service, which is just handing them the note, and then obviously there's an affidavit, usually on the CR form that says, hey, I just gave it, which the deliverer kind of gave it. And then there's other ways. I actually kind of prefer the posting and mailing as well, because you kind of get to the property and you post it on the door, take a picture, and then you mail it as well. And so I usually do a certificate of mailing to ensure so that there's never any doubt that it's mailed. Some people do a certified mail, but I don't know. I think that's a little excessive. Most attorneys I've worked with have said a certificate of mailing is sufficient. But obviously just make sure that you like real estate, that you document as many things as you can and retain them, keep proof that the notice was served.
So if I increase my rent in July up to 5%, would I still be able to increase the inflation portion before the end of the year?
Yes. So you are allowed two rent increases over the course of 12 months. So if you did the 5%, you would still be able to do the remainder. And so that part was a little vague. And I think now CAR is kind of coming forth with the amounts. And so they did say the 3.3 is what they're going based on. And so you would be able to do the additional amount.
Are the notice of termination time periods different from current law?
I guess it depends on whether it falls into just cause or fault or no fault. So if it's a non-payment of rent, it still falls under the 3-day notice to pay or quit. And that actually brings up a really good question, because one of the allowances for at fault eviction is a nuisance or some type of break in the contract. And so we haven't really talked about how to do that. And so it's a multiple step process. And the first part is what's called the notice to perform, which you give, let's say, whatever it is, if there's a pet, unlawful occupant, or whatever it is they're breaking. If it's a curable break, then you give them what's called the notice to perform. And the minimum on that is a 3-day. Some attorneys they recommend you give them a little bit more time depending on the severity, either 5 or 10 days. And then once that's, if it's not cured, then you give them the 3-day notice to quit. And that is not curable. And so that basically helps to remedy those issues on those timeframes. As far as the other ones, again, if it's a rent increase, if it's under 10%, then it still falls into the 30 days. At this point, we're not doing anything above 10%. So typically in the past, that was a 60-day notice. There are notices if you wanted to occupy the unit, and those are 60-day. So for instance, if you wanted to, your daughter wanted to move in or a family member wanted to move in, that would be a 60-day notice.
Am I still required to pay relocation assistance if my tenant makes 6 figures?
Good question. Yes, price or income or any of those qualifications actually don't necessarily apply to this. It's irrelevant it's in terms of this law.
What happens if the tenant fails to vacate after expiration of the notice?
That's another good question. Oh man, these are getting in depth. So then at that point, they would be ineligible for the relocation if they go beyond if they stay after the expiration of the time period.
We'll give it a couple more minutes to let people submit their questions. Oh, just got one right now. How much is the relocation?
1 month's rent. Yeah, so 1 month's rent. And again, if that could be applied in a different ways, it could be paid to the tenant, or it could also be applied as last month's rent. So if they haven't put a last month's rent as far as part of their initial move-in, then it could be applied for that.
Does a local just cause eviction ordinance preempt the state law?
We're getting in there, yeah. So what they're going based on is the stricter of the two. So for instance, unincorporated Los Angeles has pretty strict rent control ordinance. City of LA has a very strict rent control ordinance. Those supersede. What the City of LA did is they kept their ordinance, but they're taking the 15-year instead of the 1979 for newer construction. One of the things, and actually I was on the phone with CR a little bit earlier, one of the things that's still unclear is City of Long Beach. So City of Long Beach passed a rent control ordinance, which took effect in August. Not a fan of rent control, obviously, but that one was pretty relaxed. it took a lot, it provided a lot of exemptions. So with that one, we're still trying to figure out what's going to happen, if it's going to be piecemeal or if this new law kind of takes the place of that one. But as a rule, the stricter of the two policies is the one that takes precedence.
Excellent. One final question. Is this webinar saved for our office to play meetings? The answer is yes. At the end of this webinar, we are going to upload it to our YouTube channel. Just got to type in Greater Downey Association of Realtors to find our page, and it'll be in our webinar series. And one final question. The relocation fee is for the whole family? Question mark?
Good question. So City of Los Angeles, they have what are called qualifying tenants or whatnot, qualifying family members. And so the relocation is based on how many people are in the family. In this case, this law does not necessarily apply to that. So City of LA still has their own, which is going to be the 20,000+ or whatever it is. In this case, it's just 1 month's rent. It's regardless of how many people occupy the property.
Okay.
So we do have this. They want me to talk about it. This is a thing that's going on. It's November 14th. So that's going to be here at the Greater Downey Association. And we're going to have some people come and talk about it. Neil Kalin, who's the Assistant General Counsel, he's going to give it a legal update on what's going to happen. So if you missed part of this, obviously you'll be able to catch it through the YouTube. If not, obviously come in and kind of hear what they're talking about, as well as Jordan Levine, who's the Deputy Chief Economist at CAR. He's going to give an economic forecast on kind of what he sees coming up in the next year. And then Dan Smith, who wrote a book called Change or Die, which I think is kind of our industry right now. Obviously, our industry is constantly changing on different aspects as far as innovation and technology and legislation. So we obviously need to stay on top of everything. And obviously, this is you guys joining us as one step in doing that, because you guys are better educating yourself, and obviously that turns into value for your clients. Because, like I said, this law, at first when I saw it, I was like, sky's falling, sky's falling. Now that we understand the ins and outs of it, I think most of our clients are better prepared on what they need to do. And so it provides a lot of opportunities, which a lot of people are not necessarily in tune with.
Excellent. Well, I just want to say thank you, Jose, for coming in and giving your insight on AB 1482. I hope everyone learned a lot. I want to say thank you for everyone for attending today's webinar. Join us here at the Greater Downey Association of Realtors on November 14th from 8:30 to 11:30 for a free Real Estate Forward live stream. This live stream is sure to get you ready for 2020. Breakfast, refreshments will be served. You definitely don't want to miss that event. And again, thank you again, Josue.
Cool.
And thank you for everyone who attended.
Awesome. See you guys.